So we will start with the gentleman from California. You're recognized for 5 minutes.
Good morning, Mr. Smith. When Attorney General Garland appointed you, he cited the particularly sensitive matters at issue and extraordinary circumstances as the reason for appointing a special counsel. What did you take that to mean?
What I understood that to mean is I was to conduct an independent investigation and come to my own conclusions about whether the facts and the law supported a prosecution.
But clearly he was alluding to the fact that we had an investigation into a leading candidate for president. That was part of the extraordinary circumstances. Would you agree?
I will rely on his public statements about that. I understood my role as special counsel was governed by the regulations, which required me to make an independent decision on my own.
So certainly you would agree it was important to approach the investigation with humility and restraint. Is that fair?
Yes, and that's what I sought to do. I sought to
And you thought you possessed those qualities. In fact, you testified at your deposition, quote, "I thought I was the right person for the job." Of course, some disagreed. Constitutional law professor Jonathan Turley, for example, has said, quote, "Jack Smith has a reputation for stretching criminal statutes beyond the breaking point." I assume you disagree with that statement by Professor Turley.
I do disagree with that statement. I think my career speaks for itself. I have been
But that statement was also, and I'm sorry to have to interrupt, I just have a short amount of time. That statement was also echoed by the United States Supreme Court in a unanimous opinion in McDonald versus the United States, where the court overturned convictions that you had pursued against a former governor, criticizing your boundless interpretation of the federal criminal statute. At issue, that opinion was joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. So do you also disagree with that statement by those justices?
I have conducted my career in a nonpartisan fashion. That particular case, the legal position that the department took, that wasn't my personal position. That was the position of the department.
I see. So, Mr. Smith, I've had the opportunity during my time on this committee to review the work of two special counsels, John Durham, appointed during the Trump administration, and Robert Erb during the Biden administration. And in both cases, they seem to exhibit that humility and restraint that we talked about. But in reviewing in detail the way you conducted this investigation, I see a very different mode of operation. One that sought maximum litigation advantage at every turn, one that repeatedly circumvented constitutional limitations to the point that you had to be reined in again and again throughout the process. For example, shortly after you became special counsel, you issued a subpoena for the phone records of the Speaker of the House of Representatives over a 2-month period, along with for other senators and representatives, even though the public integrity section at DOJ cited litigation risk to doing this. What was that litigation risk?
With respect to the toll record subpoenas that we issued, they were approved by the public integrity section. The public integrity section, in approving those subpoenas, noted the fact that the subpoenas were for records for people who were not targets of our investigation.
But they said there was a litigation risk and you moved forward with it anyway. And not only that, but you also sought orders from judges making it so those who were having their records seized would not know about it. And you even didn't tell those judges that it was members of Congress whose records you were going after, in apparent contravention of a federal statute saying that a telephone provider for a Senate office shall not be barred from providing notice that the records had been requested. Now, if you sought to do that today, would you be able to get away with that, with asking the judges for a non-disclosure order without telling them these are members of Congress?
When we secured these toll record subpoenas, it was done consistent with department policy. You're correct in that that policy has since changed.
They changed the policy based upon the actions that you took. Similarly, you issued a gag order against President Trump that the D.C. Circuit Court of Appeals vacated as overbroad. Is that correct?
Mr. Smith, is Cassidy Hutchinson a liar? She was their star witness. January 6th committee, their star witness in one of those staged and choreographed hearings they paid the former president of ABC News to put together. She was, in fact, the only witness at this special prime time hearing, Tuesday, June 28th, 2022, 8 o'clock in the evening, and she told some stories. I mean, these were These were some stories. She talked about President lunged across the back seat, grabbed the steering wheel, tried to drive the car to the Capitol. And I just want to know, you think she was lying?
Chairman Jordan, my assessment of that particular issue is that with respect to the testimony about the president lunging towards the driver, my recollection of her testimony about that is that it was secondhand. She said she'd heard that from somebody.
You familiar with the name Tony Ornato?
I'm sorry?
You familiar with the name Tony Ornato?
Yes.
White House Deputy Chief of Operations, Deputy Chief of Staff for Operations, right? You remember what he said about it?
As I sit here right now, I do not.
Yeah, he said it didn't happen. How about Bobby Engel? You familiar with that name?
Yes, I am.
Secret Service agent who was actually in the car that day. You know what he said? He said it didn't happen. And they both said the first time they ever heard this story was when Ms. Hutchinson testified in the primetime hearing as their star witness of the January 6th committee. By the way, did you ever confirm her testimony about this particular incident?
We conducted, as I said before, our own independent investigation of all aspects of the case that we thought was relevant. We, attorneys from my office...
Did you ever confirm it? That's a simple question.
Well, we interviewed her, I should say, attorneys in my office before.
Did you ever confirm the president leaping across the seat, grabbing the steering wheel, this whole concoction she brought up in the January 6th hearing? Did you ever confirm that?
Right. We interviewed another firsthand witness who was in the car who did not confirm that had happened, but also...
In your deposition to the committee last month, Mr. Smith, you said this: my recollection with Ms. Hutchinson was a number of the things that she gave evidence on were secondhand hearsay. You remember making that statement to us last month in the deposition?
I did, and I was referring particularly to what we're talking about now.
Yeah, and you also said Ms. Hutchinson, regarding this particular claim, was a second or even third-hand witness. We asked you, if you were a defense attorney, how would you handle cross-examining her if she was on the witness stand? And you said, if I were a defense attorney and Ms. Hutchinson were a witness, the first thing I would do was seek to preclude her testimony because it was hearsay. You remember saying all that?
Yes, that's correct, sir.
That's correct, right? Were you going to put her on the witness stand if you ever got to trial?
We had not made final determinations as to who we were going to call as a witness. We had a large...
You were still considering her?
We had a large choice of witnesses in this case.
Are you familiar with what Washington Post reporters Carol Leonnig and Aaron Davis said in their book? They did this book, 300-some pages book on chronicling the whole investigation at the Justice Department. And here's what they said on page 310. They said, Jack Smith had wondered whether some of Hutchinson's claims might be relied upon at trial. Still, at one point, Smith told the elections team he wasn't ready to give up on Hutchinson's account. Ultimately, however, Trump administration officials uniformly, fiercely disputed her accounts under oath. Prosecutors on your team told Smith they wouldn't want to use Hutchinson as a witness in court, and Smith agreed. Are Carol Leonnig and Aaron Davis, who wrote this, are they lying?
My recollection is that I certainly had not made any final determinations about who we were going to call.
And that's the point. That is the point. The fact that they used her in a primetime hearing and you won't rule out using her, or didn't rule out using her, putting her on the witness stand when everybody knows she wasn't telling the truth, that says it all. That's the degree the left and Democrats were willing to go to get President Trump, putting on the witness stand someone everybody knows is making it up.
When you went after these people and you said, well, technically I can do that, you didn't see any selective nature or any separation of powers under the Constitution to spying on the activities and the conversations of the Speaker of the House? To what end would conversations between the Speaker of the U.S. House, third or second in line to be the President, and the President, in what basis would it be any of your business other than you believe that there was a conspiracy without conspiracy as a basic premise? You, like the president's men for Richard Nixon, went after your political enemies. Maybe they're not your political enemies, but they sure as hell were Joe Biden's political enemies, weren't they? They were Harris's political enemies. They were the enemies of the president, and you were their arm, weren't you?
No.
No. Oh, great. So you spied on the Speaker of the House and these other senators and so on, and informed no one, and in fact put in a gag order so they couldn't discover it. If they were not subjects of a conspiracy investigation, why did Congress, a separate branch that you, under the Constitution, have to respect, why is it that no one should be informed, including the judges? As you went in to spy on these people, did you mention that you were spying on seeking records so you could find out about when conversations occurred between the U.S. Speaker of the House and the president? Did you inform the judge, or did you hold that back?
My office didn't spy on anyone.
Wait a second. The question I asked you, Mr. Smith, was pretty straightforward. Did you withhold that information from an Article III judge in the process of taking the records of the Speaker of the House?
We complied with Department.
Did you hold back
Mr. Chairman, would you
information?
please instruct the gentleman to allow the witness to answer the question?
It's not your time. I'd like my time back.
Mr. Chairman,
again,
you have
please.
repeatedly done that in the past. The witness has the right to answer the question.
And there'll be due time to answer the question. Would you please put my time back and let me finish this? Mr. Smith, I asked you a question, and you were not responsive to it, and I want you to be responsive to it. Did you, whether you think it was legal or not, whether you think it was right or not, did you withhold the name of Kevin McCarthy, Speaker of the House, when you were seeking records on Kevin McCarthy, the Speaker of the House, or Jim Jordan, the chairman of this committee?
At the time the gentleman is...
No,
is- you
please
got
give
a
me
few more
back the
seconds.
time that
No,
was
no,
taken away.
Time has expired, but we're going to let the witness answer your question because it's an important question. The witness can respond.
We did not provide that information to the judge when we requested a non-disclosure order, consistent with the law and consistent with Department
Mr.
policy.
Chairman, the amazing thing here today is that we have an admission that an Article
Mr. Chairman,
I...
the gentleman's time has
come on.
expired by now 34 seconds.
It gets more than 5 minutes.
How many
'cause it's a
times you
good
going to interrupt
question?
me?
The time belongs to the gentleman from California, but it has expired.
I will be brief in my address to the chairman. We have the evidence that an Article I representative on behalf of the president withheld
Order,
from
Mr.
Article
Chairman.
III.
Point
Mr. Chairman, our witness
that
granted the
information.
same leniency.
And with that, I yield back in disgust of this witness.
Mr. Smith, in January of 2023, did you subpoena then Speaker of the House Kevin McCarthy's toll records?
Yes, sir, we did.
Yes, you did. And the subpoena covered the time period between November 2020 and January 2021. Is that right?
I'm sorry, sir, could you say that again?
We're not going to delay like this. The subpoena covered the time period between November of 2020 and January 2021. How many days after Kevin McCarthy was sworn in as Speaker did you subpoena his records?
I don't recall, but those two things had nothing to
It
do
was
with one.
16 days after becoming the highest-ranking Republican in the House of Representatives. You subpoenaed his toll records. Do you agree that that might reasonably be considered a violation of the Speech or Debate Clause?
I do not, and I want to be clear that the toll
You were
records...
collecting months' worth of phone data on the Republican Speaker of the House, the leader of the opposition, right after he got sworn in as Speaker, all around the time of a major vote. That sounds like a flagrant violation of the Speech or Debate Clause to me, and I think most people agree with me. And Speaker McCarthy had no recourse, did he? Because you issued a non-disclosure order ensuring that neither he nor any of the American people knew about these subpoenas. Is that right?
The toll record, the non-content toll record subpoenas, we did secure non-disclosure orders for those subpoenas.
You
because
did,
of
and let me
the
ask you,
risk
Mr.
of-
Smith, at the time you secured those non-disclosure orders, was Speaker McCarthy a flight risk?
The non-disclosure order was based on concerns about...
Was Speaker
obstruction.
McCarthy a flight risk?
He was not.
He was not. Then why did your non-disclosure order refer to him as a flight risk? It says right here, the court finds reasonable grounds to believe that such disclosure will result in flight from prosecution.
Sir, when securing a non-disclosure order, the risks don't have to be
You
associated.
think that the Speaker of the House is a flight
answering
risk?
the question?
No, this is not your time. This is my time. You think the Speaker of the House is a flight risk? You think he's going to hop on a plane and leave the country?
No, what I was trying to explain is with respect to a non-disclosure order, the risks aren't necessarily associated with the subscriber to the phone. They're the risks to the investigation.
I think that you were using, this was clearly in reference to Speaker McCarthy, and you were using clearly false information to secure a non-disclosure order to hide from Speaker McCarthy and from the American people the fact that you were spying on his toll records. But I've got more, so let's move on. In May of 2023, you also issued subpoenas for toll records of 9 U.S. senators and an additional representative. Is that right?
In May of 23, we did issue...
You did, and there were non-disclosure orders in conjunction with those subpoenas as well, right?
That's correct, consistent with department policy and the law.
So again, nobody would know what you were doing. The senators would, and the representatives would, and the American people wouldn't know what you were doing. Is that right?
The toll records that we secured and the non-disclosure orders were consistent with policy and consistent...
And you knew whenever you were doing that there was a risk you were violating the speech or debate clause. Is that right?
The toll record subpoenas that we secured were with the concurrence of the public integrity.
Your own analysis says that you knew there was a risk you were violating the speech or debate clause. I have it right here. This is an email from John Keller at Public Integrity Section to your team. As you are aware, quote, as you are aware, there is some litigation risk regarding whether compelled disclosure of toll records of a member's legislative calls violates the speech or debate clause in the D.C. Circuit. That's from your own analysis right there. So you did know, didn't you?
Sir, with respect to the item you just put up on the screen, the last sentence states...
we're going to get to the last sentence.
Okay.
We're going to get to the last sentence. And you cite case law in here, quote, the bar on compelled disclosure is absolute. Is that right? Or do you think that you didn't have to abide by that precedent?
To be clear, this statement is not from my office. This is the statement of the public
This is your justification for those subpoenas and NDOs that you ordered. This was part of your analysis. It's a cursory analysis. I think it's worth noting. But let's get to that last sentence then. Quote, given my understanding of the low likelihood that any of the members listed below would be charged, the litigation risk should be minimal here. In other words, you're using a novel legal theory, which you knew was novel, has never been tested by any court. You're not charging any of these members. Nobody's going to know about it because you issued NDOs. Nobody's going to sue about it, so who cares? We're going to do it anyways.
Okay. How much money did you spend in the investigating President Trump? How much money did your office spend?
I do not recall as I sit here now, but I know that pursuant to, I believe it's the Special Counsel regulations, reports were issued each 6 months detailing how much...
We gathered at $35 million. And what I want to know is how much of that $35 million of taxpayer money did you give to confidential human sources? We know you gave $20,000 to someone. It just got reported last week. How much more money did you pay confidential people we don't know about, with American tax money going after the guy we elected president?
My recollection regards the $20,000, which was not a payment from me. It was me approving a payment by the FBI to a confidential human source who was reviewing video and photographic...
Who's the source?
Evidence. I do not know the identity of the source.
How many other payments went to this source or other sources?
As I sit here, I do not know the answer to that question. My role as special counsel...
$35 million, and you're giving money to people the country doesn't know who they are, and you're giving their hard-earned money to these folks? The main question I have, too, with this is, why'd you have to do it? You subpoenaed bank records from the RNC, phone records from members of Congress. You got subpoenas for bank records for people sitting right there in the front row. Why did you have to pay people for information when you could subpoena them and get it?
Time has expired.
Time has expired. You can answer the question, though. Country'd like to know why you had to do it.
My recollection and understanding is the payment, the $20,000 that I approved, was for a confidential human source to assist in the review of video and photographic evidence showing people who were attacking the Capitol, attacking police officers, obstructing the proceeding, and seeing if we could prove that some of those people had come directly.
That wasn't my question.
Is this the complete list right here? Well, let me ask you this. Am I on this list? Did you target my records and subpoena my phone toll records?
My understanding is your records were subpoenaed by prosecutors before I became special counsel.
Well, staff would put this up on the screen. I'm thankful for the great staff who discovered the email where I learned for the first time a few weeks ago that my phone records were indeed targeted. We called AT&T and we've learned that they were given to the Department of Justice, as this email indicates, because I had been in communication with Scott Perry, one of my colleagues here in Congress, who literally had his phone taken from him in front of his family. And of course, as we've already talked about in this document, it talks about you could be in violation of the privilege by even obtaining and possessing this information if the member objected to the disclosure. This happened 4 years ago in May of 2022, and I couldn't object because I didn't know. I didn't know until about 3 weeks ago. My question here is, was there any limits to your investigation or the investigation that preceded you, Mr. Smith? Because as egregious as a violation of separation of powers this is, as an egregious and abuse of power it is, it's far more concerning you are clearly targeting American citizens for merely being conservative or supporting the president. We've got memos that we've already been talking about in this hearing from April 2022 that preceded you that establish and open the investigations, one of which has Attorney General Merrick Garland's signature on it. And the focus was the electors. Now, that was 6 months before you were appointed. You testified earlier, you met and interviewed Merrick Garland and Deputy AG Lisa Monaco, and you briefed the AG and Deputy multiple times. Did you brief them on the electors and the prosecution of their supposed crimes?
Did I? I'm sorry.
Did you brief them on the electors and their supposed crimes?
I don't recall specific conversations, but I'm sure that in the course of briefing them, I discussed.
Wasn't that the purpose of the entire investigation as it was set out? Because putting aside that in 1960, as we already talked about, my friend Mr. Tiffany, that Hawaii put forward an alternate slate of electors, the investigation pivoted to President Trump and, frankly, anybody who knew him. Do you know who Cleta Mitchell is?
Yes, I do.
She's an election lawyer that was involved in filing an election contest on behalf of President Trump in Georgia in December of 2020. A 64-page complaint with over 1,100 pages of exhibits, witness affidavits, and expert witness reports documenting thousands of votes cast in violation of Georgia law, but which were nevertheless included in the vote totals. Now, notwithstanding the disposition of the cases that was filed, is that a criminal act? Filing an election contest on behalf of a candidate for office, a client. Is that a criminal act, yes or no?
No, in fact, we
So why did you deem it appropriate to monitor Cleta Mitchell's long-distance phone records in 2023, 2.5 years after the election contest was filed and after the presidential electors were certified? What about Jen Ellis? What about Sidney Powell? What about Bill Sepien? What crime did you suspect had been committed by them that would warrant monitoring their phone records 2.5 years after the 2020 election was certified?
With respect to Sidney Powell, she is one of the co-conspirators alleged in the indictment. I don't know what you mean by monitoring, sir, if you're talking.
Well, there were some 400 plus Republican conservative groups and leaders who were targeted by your investigation. Their financial records were obtained, records of the RNC, the Trump campaign, Cleta Mitchell, the Conservative Partnership Institute, the America First Policy Institute, NRCC, NRSC, PACs, conservative groups, people all across the country, citizens, because we hear a lot about members of Congress. And we should, because of separation of powers and the egregious abuse of power. But what we're not talking about enough, in my opinion, are the American citizens that have been targeted. Because frankly, are there any limits to the power of a special prosecutor or special counsel? So much so in your abuse of power that in the summer of 2024, the indictment involving classified documents was dismissed after determining your appointment violated the Appointments Clause of the Constitution, but you continued to sign your name on court filings until the time you resigned from office in January of 2025. A federal judge just recently stated a prosecutor who continues to sign his name in court filings after a disqualification order should face disciplinary action or disbarment. I yield back.
And Mr. Smith, I'll just cut right to the chase here. Your investigation and attempted prosecution of President Trump, it wasn't about justice. It was about politics. Politics. From day one, under the Biden-Harris DOJ, you weaponized the law to go after their top political opponent. You pushed flawed legal theories, and even the far left Washington Post called you out. They called you out, sir, for violating the First Amendment. You tried to criminalize political speech, slap unlawful gag orders on a presidential candidate, and spy on Republican members of Congress in violation of the speech or debate clause, including the sitting Speaker of the House. Mr. Smith, you mishandled documents, pressured defense lawyers, and dumped a massive trove of so-called evidence right before the election, and you did it to sway voters. That's why you did it. And don't get me started on that raid at Mar-a-Lago or your unconstitutional appointment, which a federal judge in Florida rightly tossed out. A very bad day for you. This wasn't, Mr. Smith, about upholding the law. It was about tearing down President Trump and anyone close to him. You even tried to ram through a politically motivated final report after your cases collapsed, including the Presidential Transition Act and basic fairness. But here's the good part, America. Here's the good part. The American people saw right through it. They rejected, sir, your witch hunt loud and clear in November, handing President Trump a commanding victory. The voters spoke loud and clear. They wanted an end to the weaponization of our justice system. In your opening statement, you spoke about proof of beyond a reasonable doubt. Mr. Smith, I will give you proof beyond a reasonable doubt. Donald Trump winning the popular vote by over 2 million votes. The Electoral College by 85 votes, along with every single swing state. Now, sir, that is proof beyond a reasonable doubt that the crap you were shoveling did not pass the smell test with the American people. To put it bluntly, Mr. Smith, the stink remains on you. And lastly, I would like to quickly address the police officers of January 6th. Mr. Dunn, Mr. Fanone, Mr. Gonell, Mr. Hodges. I'm a member of the new select committee to actually examine what happened that day. And I can tell you, gentlemen, that the fault does not lie with Donald Trump. It lies with Yogananda Pittman and the U.S. Capitol leadership team. We know they had the intelligence, and there was going to be a high propensity for violence that day. Claim my time, yeah.
You will be in order. The time belongs to the gentleman from Texas. We've had some disruptions already. We don't need that. Let the gentleman may continue.
We know the Capitol leadership team, specifically Yogananda Pittman, had the intelligence, and there was going to be a high propensity for violence that day. And the Capitol itself was the target. We knew the extremist groups were going to be there. And why do I say that? It was your own report from your intelligence section, the IICD, which was run by Pittman, in the January 3rd special events section. It was in it. It was in it. And Mr. Dunn, I believe that you thought that day would be like just any other. In your testimony to the January 6th committee, you said you found out how ugly was going to get on a cell phone. Somebody sent you some information on social media. The point is, you were all unprepared to deal with that day. And that's because your leadership failed to share the intelligence with you. It was their fault, folks. It was their fault. It was not President Trump. And we are going to expose it for the first time because the Benny Thompson, the sham committee didn't do it.
Will the gentleman yield for a question?
The sham committee didn't do it. The report is 845 pages. Donald Trump's name is mentioned 4,207 times. We know what the committee wanted to do is to not allow Donald Trump to come back and win again. And they failed miserably. And I hope you now can see that. With that, Mr. Chairman, I yield the balance to my distinguished colleague out of Jersey.
I just want to quickly go over something because we keep rewriting history. The president said peacefully and patriotically. What don't we understand about peacefully and patriotically? He asked for the National Guard. That was ignored. He asked Speaker Pelosi. What don't we understand that?
Will the gentleman yield for a question? Are you saying Nancy Pelosi controls the National Guard?
Wait a minute.
The president could have ordered the National Guard if he wanted to, and you know that.
My time. I lost some of my time.
The time belongs to the gentleman from New Jersey. You have a few more seconds.
And finally, how many elected officials say we're going to fight to win an election? It's new terminology used all the time, seriously. And of course, if they were guilty, they should be prosecuted. The problem was there were many in the mix.
Mr. Smith, it was during your deposition with our committee that you revealed that you tasked your team, specifically J.P. Cooney, to engage with the partisan January 6th committee. You had to have known at the time the controversy surrounding this committee, including the fact that all of the members had been appointed by Nancy Pelosi, who disallowed the Republicans from being able to engage. Yet you proceeded anyway, raising numerous questions as to your strategy for conspiring with the J6 committee. You had every possible resource available to you. Your prosecution of President Trump was clearly a priority for the Biden administration, and it is clear that you had an unlimited budget. And you also left no stone unturned, even subpoenaing records from sitting members of the House and Senate. So what information could the J6 committee possess that you and the nation's top law enforcement agency could not obtain on your own?
I did request J.P. Cooney.
What did they have that you couldn't obtain on your own?
In any investigation, you
What information did they have that you were not able to obtain on your own?
I couldn't know that until I had their information.
Was there anything there? Did you find that they had information that you were not able to obtain?
I don't recall specifically every bit of information. What I can tell you is we took in their information because we wanted to collect any information that could be relevant. We made our own independent assessment of the evidence.
Okay, so from the time that you were appointed as special counsel up to the date of your resignation in January of 2025, did you personally have any contact with any members, staff, or contractors of the House's January 6th Select Committee, and if so, who?
I do not believe I had contact with anybody personally from the January 6th.
The January 6th committee failed to archive or preserve its video recordings of witness interviews, deleting or destroying as many as 900 interview summaries or transcripts involving more than 1 full terabyte of digital data. I repeat, the J6th committee destroyed evidence. Let that sink in. Why would they do such a thing? I think we have a dang good idea. The committee actually used selective clips from these videos and transcripts during their hearings, and yet by destroying this evidence, they have denied Congress and the public the ability to obtain their full content and context. They created their narrative by selective use of the evidence before them, so how very convenient. Did you or your team receive any of those witness transcripts or video recordings of transcribed interviews from the Select Committee that were not released to the public?
What I can tell you is that I requested J.P. Cooney to contact the Select Committee.
Do you know if you received any of the evidence or testimony that the J6 Committee eventually destroyed?
I don't have any information that the J6 Committee
You don't know
destroyed
one
any
way or
evidence.
the other as you sit here today.
No, what I'm telling you is that I requested all the information we could get from the January 6th.
Has all of the information that you requested been preserved? All of the information from the J6 Committee, has that been preserved?
The information that we requested and received, we reviewed it. It was
Has
part
it been
of our
preserved?
Files. Yes, as part
Thank
of
you.
our files. And
Were you or your team advised, or did you get the impression from anyone affiliated with the January 6th committee that these documents were not for public release, even though portions of them had already been shown to the American people? Were you advised to keep any of the information from the J6 committee confidential?
as I sit here right now, I don't recall that.
Okay.
I recall.
Did the J6 committee provide you with the Cassidy Hutchinson testimony as part of the trove of documents that you received?
As I sit here now, I don't recall, but it would
Well,
be very
you're familiar with her testimony, aren't you?
I am. And
in fact, wouldn't you agree with me that Ms. Hutchinson's testimony, especially the most explosive allegations made, was comprised of hearsay upon hearsay upon hearsay? Come on, you're an attorney, Mr. Smith. You can answer the question. Of course it was hearsay. And hearsay isn't admissible in a court of law, is it? Why? Because it is inherently unreliable, and the victim or the target of a prosecution is not able to cross-examine. Isn't that correct? In fact, Mr. Smith, if you had attempted to walk into court with Cassidy Hutchinson's testimony, you would have been thrown out on your ear. No judge, no legitimate judge would have ever allowed the testimony of Cassidy Hutchins to be admitted in a court of law, would they?
I disagree.
When was the initial indictment issued on President Trump? August 1st, 2023, does that sound about right?
That's in the election case. That's correct.
Correct. And on that election case, after that, you asked for a trial date when?
I don't recall as I sit here right now.
January 2024, does that sound about right?
That sounds about right.
Okay, so after the indictment, you in August, you asked for a January trial date. That's like 5 months? 5 months? How much evidence did you have? Millions of pages?
As I sit here right now, I don't recall the exact.
I think in your testimony they talked about a number, 13 million pages. Is that a ballpark accurate number?
I think that was the question asked of me, and as I sit here, I don't have an accurate number for
So let's just assume that that's true, right? Because you had a bunch of stuff. You had $50 million that you blew through the Treasury on a trial that went nowhere. How many pages per day is that? 100,000? That sound about right? What if we break that down per hour? It's 4,166 per minute is 70 pages. You like to read, sir? You like to read?
I do.
Do you read 70 pages a minute?
I do not.
I mean, that would be remarkable. So how do you prepare for a trial in 5 months if you're asking the defense counsel to read 70 pages a minute? How do you do that and prepare a defense and look at all the witness testimony and video evidence that you supposedly had? How do you do that? You know what's shocking to me, and I think that one of the most egregious aspects of this case, Mr. Smith, is that if you get a traffic ticket in Washington, D.C., you're not going to trial in 5 months. But you want the president, the former president of the United States, to have a trial date with 13 million pages of documents within 5 months. I think that's ridiculous. And I think that speaks exactly to what we talk about when we examine not only your record, but the things in this case that are deeply troubling. That this was not the pursuit of facts and law and letting the judge and the jury decide. That this was an exercise in it was a political hit job, timed perfectly against the President of the United States. Sir, in the Florida case, in the records case, what happened ultimately in that case?
What happened ultimately in the case?
Yeah, the Mar-a-Lago records case.
I'm going to answer because I don't think this is covered by Judge Cannon's order. We moved to dismiss that case pursuant to Justice Department policy.
No, the records case in Florida.
Against Donald Trump.
The records case in Mar-a-Lago, were you ruled to be, what was the ruling in that?
That was Judge Cannon's ruling, and she ruled my appointment unlawful, and we sought to appeal that, and that appeal was pending at the time that we dismissed the cases.
So from the very beginning, were you ever confirmed by the United States Senate?
I have never been confirmed by the United States Senate. I will say that the history supporting my appointment is over 100 years old. Other special counsels.
But isn't there a statute on the appointment? I mean, you have to be confirmed by the Senate. So I think that's kind of interesting. But I think the point is, from the very beginning, on the documents case and others, you weren't even lawfully appointed, and that's why Judge Cannon ruled the way that she did. And from the beginning, we talk about that you followed Department of Justice policy, you followed the facts, you followed the law, you followed the Constitution. That's what you have said all throughout this day, parroted by the Democrats, that you have done nothing wrong. But from the very beginning, you weren't even lawfully, and you can't even recall who swore you in. So as we sit here today, based on your testimony in the transcribed interview, can you tell us who swore you in as special prosecutor?
As I said, I know I took the oath of office. I don't recall who swore me in. What I can share with you.
I don't know, sir. Call me naive, but that's a milestone career move for you that you get to do this, and you don't remember the circumstances. I just find that a little bit odd. But here's the thing, and I'm going to wrap up quick. You're unconstitutionally appointed. You breached the 60-day rule, releasing this very partisan attack against the president right before the election. You tampered with evidence in the Mar-a-Lago case that you admitted to in court filings. You subpoenaed members of Congress and their phone records in violation of the Constitution, of current statutes. You didn't even let the court know that these were members of Congress. How are we to assume otherwise that this wasn't political? Because it absolutely